Thank you. Kia ora. Te mihi tuatahi, ka tira ake kia koutou kia tātou. Tuatahi ake korore ake te atu arungarawa. Tuaru ake nama te huhua nei o te wā. Haere rā koutou, moi mai, moi mai. Moi mai kia mātou e mahu e tia mai, te hei Māori ora. He honore ki te ariki nui, hakuini nā wai hono i te pō, taino i te whare tapu a pōtatau. Rire rire hau, pai marire. Koutou, te mana whenua, ki pōneke te ati awa, Ngati toa, Ngati Raukawa, koutou, i roto i te whare parimata, karanga mai. Mai te maunga o tau piri, haere tonu atu ai ki whakapau nākau, ki pōhoturoa, nei ngā waka e rua nei a tainui, roto ai a te arawa, e konei a mātou ngā marae e toru, ko te marae a tau piri, o Ngati Ngaungau, ko te marae, ara o te Pākira, Ngati Wāhiao tūhaurangi, me te marae o te mātai kōtare, o Ngati Rangi Te Aorere, e tuati nei, tēnā koutou, kia ora koutou katoa. My name is Hone Tarawhiti, and joining me today are my colleagues, my brethren in Whanaunga, Laurie Paul, from Te Mātai Kōtare, Ngati Rangi Te Aorere, and also Sharon Porter, also of Ngati Wāhiao Tūhaurangi of Whakarewarewa, and Rangi Wade, who is also here. I take it that you have received my submissions, and I take it that it has been taken as read. As I said in my mihi, I'm here on behalf of the three hapu and the marae that I represent today for these submissions, and I first would like to say we oppose the principles of the Treaty of Waitangi Bill. This bill should no longer proceed. And secondly, the Crown should adopt the recommendations that were set out in the Ngā Mātā Pono report written by the Waitangi Tribunal. Thirdly, it takes two parties to make an agreement, but it only takes one to break it. In the principle one, the Government of New Zealand, with the full agreement of Parliament across all parties, should have the authority to govern and make laws in partnership and in genuine spirit of our country's founding document, Te Tiriti o Waitangi, upholding the original version in Māori with consultation with tangata whenua, in order to ensure the rights of Māori are firmly embedded to allow a balanced rule of law and transparency of our democratic rights are upheld. Nā te kawana o Aotearoa, tai atu te whakataitanga. Oversimplification of treaty principles, hei whakahāwea ngā tikanga o te tiriti. This bill reduces the complexity of the treaty into a vague one-size-fits-all tikanga. The treaty is an agreement that was entered between the Māori and the Crown. In any agreement, it takes two parties to make that agreement, but it takes only one party to break the agreement. This bill allows the Crown to change the relationship between themselves and kia tātou te Māori and us the Māori. They have done this by themselves, and therefore, without our consent, we submit that in the issues as significant as this, the Crown should have to obtain consent from Māori, such as our tribes, for our people before any policy has been developed. In our principle two, our case, our submissions is that the Crown first acknowledged the sovereign right of tangata whenua that reflects the views of hapu and iwi, whom are the lawful signatories of the Tiriti o Waitangi. The Crown recognises these rights monumental to Aotearoa. These rights are memorised or memorialised within all aspects of our communities, not just treaty settlements. This fails, the principles of the Treaty of the Waitangi Bill fails to acknowledge the unique context and evolving needs of our Māori communities. I would like to quote for an example of a person that I know that has lived all his life on a pā in Taupiri. His father was challenged by his elders to build a marae for his people. This man was illiterate, couldn't read, could not write, didn't even know how to speak Māori, because he came through that gap of those generations where their parents were beaten for speaking our language, our reo. However, this man continued on and he finished building a mega and beautiful state-of-the-art marae. At the same time, he also created, revived, and also promoted the use of riparian planting. So good was this that he was recognized in Europe, in Sweden, and in Denmark, where he received international awards for somebody who couldn't write. My point here is that this bill will make people like this gentleman more vulnerable. It's not just his inability and his deficiency, it's the potential within our people. And the only way we can harbour that is to make consultation. Just like Ngāti Wāhiao here in Te Arawa, we celebrate the return of our lands of arbitration reserve, but we had to fight for that. Just like Rangi Te Aorere, they got their lands returned of the church, the Te Ngai Mission Farm. So these are just some examples. The Crown is attempting to redefine the principles of the treaty by themselves. The relationship between the Crown and Māori has always been defined with communication. Kōrero, tētahi ki tētahi, between parties going both ways. By not consulting with hapu and attempting to draft this bill without Māori input, the Crown has breached its duties as a treaty partner kia tātou te Māori, to Māori. We submit the Crown must consult Māori on legislation. On principle three, the high part I'd like to highlight is that the Treaty of Waitangi is the governing law that protects the rights of Māori and Pākehā defined by our laws. Equality does not suggest for other cultures or other nationalities to determine the law. There must be a law that is segregated, that does not erode our sacred, cultural, traditional, and spiritual values of our marae and our iwi, of the treaty signatories before the wider public of New Zealand. The gap of post-treaty breaches to cultural practices and traditions affected our people beyond recognition. Our marae is proud, our maraes are proud. Here, Te Pākira, our marae of Te Mātai Kōtare and Taupiri are proud that the relationships forged between our treaty partnerships, taking that away would take away our voice. the Crown's involvement interpreting the treaty principles, the impact on our maraes. The impact on our marae life is deeply rooted into tikanga, which varies across different Māori communities. The imposition of the Crown-led principles could challenge the ability of marae to conduct ceremonies, governance, community events in accordance to our specific cultural customs, our kawa. This would dilute the authenticity of marae practices, as they may be forced to align with the state's interpretation of Māori culture. No credibility because of no understanding of te reo. In promoting this bill, Mr. Seymour has attempted to change a culture that he has no understanding of. Mr. Seymour cannot speak te reo Māori and does not know of the customs that drive the Māori people. How can Mr. Seymour interpret what he has been said, or what has been said in te reo, when he has no knowledge of our language, ladies and gentlemen? This bill has no credibility because the person who is the driving force behind the bill has no credibility to comment on any agreement drafted in our language in te reo. As stated in my submissions, I speak on behalf of 3 marae which are here present today. Te Pākira Ngāti Wāhiao, Te Mātai Kōtare, Ngāti Rangi Te Aorere, and Ngati Ngaungau of Taupiri Marae. The recommendations is that I would like to make a recommendation on the points that we have promote workshops on the status of the principles of the treaty on specific days of significance, such as Waitangi Day, even Matariki, that we uphold this. So in conclusion, before I run out of time, we say as a tribe, there is no credibility, there is no consultation, there has been no consent, and there has been no involvement to enhance te reo. Koe rā I taku kōrero e raku rangatira mā I tēnei rā kia mātou I tēnei ata. No reira, koe rā te whakaro o tātou, hei kotahi tātou I raro I te kaupapa I tēnei rā, tēnei tuku te mihi atu kia koutou, I tukuna tēnei wahanga kia mātou tai tawhiti, I roto I tēnei rā, no reira e aku rangatira, kia pau aku kōrero, tēnā koutou, kia rā ki tātou kapo.
Kia ora, Honi, thank you for your submission. Well timed, bang on 10 minutes. So we'll just, on behalf of the committee, thank you for being with us this morning. First up, 8 o'clock, it's always a tough spot to fill, but we appreciate you being with us this evening.
Alrighty, okay, so go back to panel screen 2. Yep, sweet. Okay, what did we think of that submission? Any thoughts on that?
That's a really good point. Like,
Yep.
David Seymour has said that he doesn't speak te reo. Therefore, how can he know what is in the te reo version of Te Tiriti?
Well, he won't. I doubt David Seymour has the ability to just read the plain text. He has to go through interpretation.
Exactly.
But you know, there is a really good translation by Sir Hugh Kawharo, who is an anthropologist. But his writings are part of the cabinet manual. His translation. So David Seymour has access to a very accurate translation. He just doesn't like that translation. He prefers the interpretation by let me just get my notes, by Sir Apirana Ngata, which, you know,
saying that Māori ceded sovereignty, even though it has been proven over and over again that, unfortunately, Sir Apirata didn't actually know what he was talking about.
I mean, yeah, I mean, I read through his little booklet. It's clear that he could read Te Reo Māori and speak it. That much is clear. I'm not going to take that away from him. But there are issues with the way how he's translated it.
Yes.
Like, for example, he uses the word mana and rangateratanga synonymously, when those two words are not, they don't mean the same thing.
No.
They have different contexts. But also, when we're looking at the Māori language of the text, right? Rangatira gave the crown kawanatanga, or government, not rangatiratanga, which is chieftainship. So these two things are very different. And by giving kawanatanga, rangatira agreed to the governor having authority to control British subjects in New Zealand, and therefore keep the peace and protect Māori interests. Rangatira consented to the treaty on the basis that they and the governor would be equals. So yes, they gave the English the ability to set up a government here and to set up laws that made sense to Pākehā, right?
Yeah.
So basically, that's where the 3 Ps come into play, and you've got the concept of partnership, right? So yeah, that's pretty much what I'm going to make a joke here. Ngati no to this bill. No, that is not the iwi. That's not the tapu that he's from. But I just thought it was. I just wanted to do it funny.
Yeah.
But yeah, I mean,
well
I say Ngati no to this bill.
Well done.
All right. Should we pop on to the next one?
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok. Who's got the Order Paper Podcast? language is a